Assalamualaikum and hi, I'm Anis Nabila binti Azam with matric number 066894. So in order to identify the issue, the first one we need to do is to understand what the case is about. Let me read the case first. Suhaimi, Amber and Daud are directors of Stapler F. Sdn Bhd, an artificial growth supply company. Daud was given a task to find land to build a new store. Daud then entered into an agreement for the purchase of a piece of land in Raub Pahang for 900,000 ringgit. The land was owned by Nurun, Daud's sister, but this fact was not disclosed to the company. Stapler F. Sdn Bhd has now discovered this and wishes to sue Daud. On another occasion, Amber secretly set up the same business with the new company and became the competitor to Stapler F. Sdn Bhd. So after understand the case, we can now identify two issues in it. The first issue at hand is whether Daud can be sued for his unravel connection with Nurun, and the second issue is whether Amber's secretive dealing can be punished legally.
Directors in the company are subject to certain duties, for instance, under Section 213 of Companies Act 2016, which is to act in good faith, exercise power for proper purpose, avoid conflict of interest, and exercise appropriate level of care, skill, and diligence. Under Section 218(1) of the Companies Act 2016, CA 2016, it stipulates that one of the duties as a director is to avoid conflict of interest. The more detailed explanation is that a director or officer of a company shall not, without the consent or ratification of a general meeting, use any of these phases in the company. The first facet under Section 218(1)(a) of the Company 2016 is the use of the property of the company, such as using the company's fund for their private agendas. Next, the use of any information acquired by his position as a director or officer of the company under Section 218(1)(b) of the Company Act 2016. Furthermore, the usage of his position as a director or officer under Section 218(1)(c) of the Company Act 2016. Additionally, the use of any opportunity of the company which he became aware of in the performance of his functions as the director of or the officer of the company under Section 218(1)(d) of the Company Act 2016. Lastly, engaging in business which is in competition with the company under Section 2018(1)(e) of the CA of 2016. All of these conflicts can make the director stand to gain benefits for himself, all in while causing detriment to the company.
Assalamualaikum and hi, my name is Nuramada binti Renzi and my matric number is 068160. Another example case that relates to Section 218 in bracket 1 under Companies Act 2016 is Shanghai Hall Ltd versus Chong Moon Fu. This case involved a conflict of interest between the directors of a company that ran a restaurant and bar and another company that had a similar business on the lower floor of the same building. The company that ran the restaurant and bar sued its director for not disclosing their involvement in the competing business. The High Court ruled that unless the company's articles state otherwise, a director could join another company that compete with the original one.
An example case relating to Section 218 in bracket of 1 under Companies Act 2016 is Aberdeen Railway Company versus Blakey Brothers. This case concerns the fiduciary duty of a director and not to engage in self-dealing. The situation is that Blakey Brothers had a contract with Aberdeen Railway to make iron chairs and is trying to sue Aberdeen Railway to enforce the contract. In their defense, Aberdeen Railway proclaims that they are not bound to the contract because the chairman of their board of directors, who is Thomas Blakey, was also the managing director at Blakey Brothers, which resulted in a conflict of interest. The court finally held that Aberdeen Railway is rightfully not bound to the contract. This is because the court concluded that personal interest would lead and induce Sir Thomas Blakey to fix a high price which is not in favor of Aberdeen Railway.
So for the first issue, by referring to Section 218(1) and 231, from the Companies Act 2016, Stapler Sdn Bhd can sue Daud for a conflict of interest and failure to act in good faith. This is because Daud failed to disclose that the owner of the land that he's entering an agreement with was his own sister, which is Nurun. This information is important because Daud can gain an indirect benefit from the agreement, and he can be tempted to buy the land at a much higher price for his own personal private gains. Well, what this means is Stapler Sdn Bhd will be financially negatively affected by the deal, which obviously contradicts Daud's duty as a director in Stapler Sdn Bhd. To further support this statement, we can see a case such as Aberdeen Railway and Blakey Brothers. This case is quite similar because Sir Thomas Blakey also failed to disclose that he is also a director in Blakey Brothers, and he can also be induced to raise the price of an agreement to gain private benefit, all while negatively affecting Aberdeen Railway financial situation or company.
Assalamualaikum and hi, my name is Nurul Aina Najwa binti Ramli 068779 for the second issue by applying section 218 in bracket 1E and section 213 in bracket 1 of the Company Act 2016. Stapler Sdn Bhd can sue Amber, who secretly set up the same business with the new company and became the competitor to Stapler Sdn Bhd. This act clearly ignores the duty of Amber, which is to act in good faith for the company. Amber did not collude with Stapler F's competition, but worse, she helped create the competition. To support the statements using a case, we can use Shanghai Hall Limited versus Chong Moon Fu. The defendants, who were also directors of the plaintiff firm similar to Amber, had a comparable business on the floor directly underneath the plaintiff.
Assalamualaikum warahmatullahi wabarakatuh. My name is Masyahidatul Zulaika binti Musbah. My matric number 0C8783. So, as a conclusion, Stapler Sdn Bhd can sue Daud and Amber for breach of the duty as a director of the company. The directors are prohibited from taking advantage of their position in the company for their own benefit. That's all from me. Thank you.